Essentially.
No, probably not.
I believe, do we have the language in front?
Yes, sorry.
No, that's okay, don't be still here. Way ahead of. Okay. And you're joining the Zoom?
I'm trying to get my laptop for the moment. Yeah. It's been
Here you go, Randy and David. Here you go, Thomas. Yeah, you stick that on her computer.
Our line.
Okay, great. Welcome back to Senate Economic Development, Housing and General Affairs. It is still Wednesday, the 20th of May. So, Rick, we voted out H639, genetic data privacy. It went back to the House. We were hoping they would simply concur. They have agreed to our 2-month cure period. And so that was great, but they, in discussion, thought what they consider, they have a concern about something they thought. And so if you would be kind of to explain what they felt they thought and discuss that and what their remedy is for that. And
sure. So,
yeah.
Ray Sagal with the Office of Legislative Counsel. So we're looking at H639, the House Proposal of Amendment. It is one instance of amendment, and it is in the enforcement section. So the version that passed the Senate had a 60-day cure period for any alleged violation of the act, where a consumer would have to contact the business controller, actually in this case, it's a direct-to-consumer genetic testing company, if there was an alleged violation. Okay? So the House concern was, what if it is some type of sale of genetic data or some other alleged violation that could not really be cured? So they suggested that the 60-day cure period be limited to a few less harmful, I guess, situations.
Yeah, Madam Chair.
Yes, Thomas.
What situations are uncurable?
So, yeah, great question. I have the bill pulled up. So the House felt.
Actually, that my follow-up is going to be.
Yeah.
Seems like during a cure period, it could then very rapidly be deemed whether or not it is curable. The cure period is really just a delay to collect information to allow for the correction of these things. Why couldn't it just be deemed during that period that it's incurable and then it would continue on in the process?
What
Yeah.
qualifies as incurable?
Right. So it could, if the business claims that this alleged violation, first it had to kind of admit, right, that this happens,
Yeah.
and this can be cured, right?
Who would admit that it can't be cured, and why would that admission occur during the or rightfully be considered during the cure period?
I guess so. The business would get this letter from the consumer saying that I believe that my data was sold or was shared without my consent. Right? So in that case, the business would get the letter, and on the Senate version, it wouldn't matter what the alleged violation was. It'd be 60 days. Under the House version, let's say that the consumer claims that my data was shared without my consent. That's not true. The business may deny, number one, that it did that, and there would be ongoing, at some point, maybe litigation. If, as you said, if there was a Senate version where the 60-day period was required, the business would either say, we didn't do it, we didn't share your data, we didn't sell it, or they could say we did, and
We'll get it back.
right. So that's, I think, the difference of opinions. The House believes that that can't be done. Like once you sell it, once you share that kind of thing, then it's out there. And
Generally, I agree with that. Yeah, so I'd say that if you gave data to another entity, you could say, I need that data back, and you don't have the right to use it, and that can hold water. But I guess I want to be persuaded that once you sell data, that there's no recourse or recollection or correction or cure.
yeah, I guess the argument is the third party that received the data, that sold it. The consumer would not as easily be able to hold that party accountable. And who knows what they've done with that data, right? Since once you sell it to somebody, that entity can do whatever they want. They can publish it, they can sell to
Put
someone
it on the
else.
internet for 1,000 other people to get, you know.
And the consumer would have a harder time tracking down, right,
That
that.
can still be determined during the cure period. So the cure period, they'd identify that, and then the end result would be effectively the same as this language. It would just have that time period to let people get their ducks in a row, talk to their lawyers, figure things out, possibly resolve it, and otherwise still give consumers the same legal right to sue at the end of the cure period.
Yeah, they would still be able to.
So what do they think is so incurable? I guess that's what, because there's, if you could just go through the two instances that they considered.
Sure,
Your-
sure. And I do want to maybe part of the reason that a law would not allow a cure, the idea, and you can disagree with it, anybody can, is that merely not allowing a cure would make the business hopefully not do the thing that you don't want them to do, right? That's maybe part of the incentive is that this is not curable. So you got to be really careful. Do not sell or share.
Right.
But again, that's debatable. And
So what is not curable?
Okay,
I guess
so
my question.
the house version, specifically 2421. Well, most of it's not curable. Let me highlight the things that are curable. That's what's actually highlighted in the House bill. So 2421 BA1 is the privacy policy. I'll show you exactly what that is. So 2421 BA1. So if a direct to consumer genetic testing company, they did not provide the privacy policy, which lays out their collection, use, and data, that is curable. So a consumer would say, hey, you didn't provide this privacy policy. They would have 60 days to provide that to the consumer before the consumer could actually.
So that's not data really, that is a
Right.
Procedural process cure.
24, so that's one, just subdivision one. An example was not curable two. Okay, so a direct consumer genetic testing company shall obtain a consumer's express consent for the collection, use, and disclosure of their genetic data, including at minimum separate express consent for the following. So everything in two is not curable.
According to the House.
Yes.
So the House feels that all of that is not curable.
But that needs to be adjudicated. It needs to be evaluated. Anybody can make a claim. Trial attorneys can send letters, and then the company needs to have time. That's what a cure period would do, to be able to respond in that. So I still stand by our original thing. The only vote that is against concurring, say la vie.
No, that's why we're hearing it, just so we can decide what we're going to do.
Fair enough.
2421. Oh, it's funny. What are you talking about? I would prefer, yeah, no, hey, I'm with you. 2421 BB, the marketing exception. So if a consumer, this is curable. So if a consumer is marketed to in a way that this bill prevents, which means off their website, if a consumer gets for some reason, ad targeted them on a third-party website that involves their genetic data or something that they got as through the service, that is prohibited. However, that is curable. So a consumer would have to allow 60 days for the company to delete or, remove that targeted ad that is sold or shared with a third party. Okay. The last curable is the discrimination piece. Way down here in subsection F, discrimination. So if a consumer has one of these elements of discrimination against them because they chose to not consent to something, that is curable within 60 days. So if a company charged a different price because the consumer didn't agree to consent, that would be curable by the company. They could
So sort of some of the process pieces are curable, some of the
privacy policy.
privacy policies, some of the
Marketing.
policies are curable, but the House committee and the chair has just arrived, so I'm gonna let him
Yes.
explain. So it might, if you just pull up a chair with Rick, let's not bother, let's just do this together. So, Mike, share with us, good morning. It's good to have-
Chair.
Good morning, Matt, Mr. Chair. It's good to see you. Thank you very much. Your committee had concerns with certain genetic data. Once sold is not able to be cured. And once it's sold and out of, so could you share your committee's concern and why you think these pieces are incurable?
So for the record, Representative Michael Markov from Coventry, Chair of House Conference and Economic Development. First, want to say that, you know, you and I had a conversation, about this cure period that we agreed to.
Yeah.
However, when the committee looked at it, we found that the genetic data was also included in the cure period. I think the Senator Ron Hinsdale's analogy on other things, it's like once the toothpaste is out of the tube, you can't put it back in. Once your genetic data is out there, you can't recall that. So how do you cure them? There's no cure to it. So, we were fine, and we had discussions about a cure period prior to that, before we sent the bill
Like
down.
yours was shorter, as I
It was a
like,
14 day.
14 day.
That's, the committee's comfortable with that. You know, we had discussions last week and they became comfortable with 60 days as long as we can, not put the, you know, include the genetic data.
Thomas.
So say it's incurable, that a trial attorney or a consumer has deemed that the data has been sold and is making that claim. What is so terrible about giving the company the 60 days to come to that same conclusion that it is incurable, and then the consumer still has the same rights at the end of those 60 days? But that way, at least there's a process, a time period where the company could, if this is in fact a valid claim that the data was transmitted, sold, or otherwise sent to a third party, could get it back, could declare whoever they sent it to, we were not right to send that to you, need it back, we need you to delete it from your records and tell us everywhere else it was shared.
So I think for a consumer to file a lawsuit, private right of action would have to show injury that they had, that there was some injury caused to them. Now,
Could that not be done at the end of the 60 days, just as easily at the beginning?
sure, but why would we extend their right to cure? If they were injured, why would we want to push that out another 2
Because it
months?
hasn't been deemed or agreed to that they have been injured yet, to give both sides,
That's what the courts are for.
at least giving the company some time to consider the claim, to look into it, validate it, respond and rectify it.
We were fine with everything else but that.
Okay, so, and it's the two people. So David and Randy, and thoughts on your,
Well, if I get a scenario in which the data could be, with some assurance covered, for example, and, with evidence that it had not been misused. Example might be, you know, a transmission, some sort of secure transmission to another company, and evidence, whatever that may be, that the company did not transmit it, did not copy it, did not do anything with it, it remained in the locations that it was shipped to, that it was sent to.
Then there wouldn't be any injury to the,
It wouldn't be an interview.
any injury to the.
Well, the person who's raising the action might simply say, I know that ABC company took my data and they sent it to XYZ company. And therefore they violated by whatever, so on. And ABC company could say, yes, we sent it, but we sent it to this, which is a related company of ours. And we know that it was transmitted there in a sealed box. It was not opened, it was not copied, it was not so on and so forth. And they provided evidence that to that effect, what might that be, I don't know. Would that perhaps be curable?
who knows? I mean, that's a hypothetical. I mean, I would have the same question about data research. So, you know, if they stole their data to a research company, and that is the kind of data that could be cured. I mean, no one's stealing your individual genetic data. They're using it for a research project. So that kind of thing strikes me as very curable. If you're selling genetic data so that you can be better identified by ICE or by a law enforcement or, you know, that, I mean, I can see there are some areas that once it's sold to a company that's going to then use it immediately, that's very hard to hear. I mean, I think you're gonna have to catch that, Thomas, to go to your point. You're gonna have to catch that right away and start action on it immediately.
But if you don't have the cure period for those circumstances, my understanding is it goes straight to the courts where you have to hire attorneys or it gets to a whole other process and it's very expensive. Litigation's expensive. With the cure period, there's at least an internal time period where the company can respond to the best of their ability, resolving it without having to show up to court, hire attorneys and so on. The cure period seems valid, especially in this space that, I just don't see how we're not taking away consumer rights by giving companies 60 days to consider the claim before it then proceeds with the step that would have otherwise occurred that first day. So I still support the
Right,
But I'm just
like
wondering-
litigation costs both sides.
So I guess I remind you that if the consumer consents to the sale, there's no problem. The problem is when there's no consent, and that a company decides to sell that data. And the 23andMe issue that happened was something that a lot of people were afraid of, that their genetics were going to get out into sunlight.
Right.
And
And be
that's
used against.
right.
So,
And you know, in that case, I don't know how you do it.
so I think one of the things that gave us some comfort is that we looked at the companies, just like you, all the companies came in. And we looked at some of them, and a lot of them have consent after each section. So that which is very useful. And instead of, as Randy always says, having that huge long list at the end that you have to wade through, but they have consent sort of section by section, which is very helpful.
We had a lot of comfort with that.
Yeah, and that gave us, I think, the comfort to do the cure, at least it gave me the comfort to do the cure period. And I guess, given that there are only, am I correct in understanding there are only 3 major companies that do genetic?
There are 3 major things, several hundred that are in the marketplace. Anybody can do something and claim to do. Quality, diversity, and so on, handles it. The issue is how you cure is almost a question that you can't answer. If they would have to answer it, I would assume they have to answer it to the satisfaction of the attorneys for the other side. And they could accept it, or they could say, they could raise a case that this is not a valid way to measure whether or not the damages has in fact happened. Or the use of the product has been genetic data. And I'd say, is it worth at least giving them a chance that what they come up with is the evidence is kind of satisfied the other party and the court.
If we'd had this law in place with 23andMe, would we have been able to? Well, the concern was greater than the reality, as I recall. That the reality was that
Possibility was there in the end, so.
And if there was in fact a cure period, so that the defendant would have the ability to answer that, hey, you weren't really damaged. You could have the litigation expense that everybody has to go forward and find, yeah, you did something wrong, but there was no damage.
Right, and you're not,
And so everybody, the only people who got rich on this then were the lawyers because of litigation. But, you know, the fact that you give the cure period does not give the violator any long-term benefit, because if the damage has already been done, they can't, you know, they would recover anyway.
so the incurables you feel are pretty much all the genetic data. That's sort of what is that correct?
with,
And that the curables are really just the privacy statements, the privacy pieces, and sort of the administrative pieces are the only pieces you see as curables. Got it. So, well, thank you. Right, that's helpful. I'm not. So David and so Randy, I think it sounds like you're still supportive of our position. We have 2 options. Obviously, we can concur, and we could concur with a further proposal of amendment by striking that, or we could agree to not concur and should go to conference. And
And
so
one
I
of the
think,
things that could be done is meantime, is develop some evidence using experts. Tell us, how could the damage, what kind of circumstances would constitute a curable action? So that if perhaps if
Or-
they had examples in front of them, and I don't know whether they produce or not, I'm just speculating.
I think
With that,
the only thing that I've heard from talking with the lobbyists that represents Ancestry is that if they, for some reason, sent someone data outside the United States and to one of their other places outside the United States, there's no damages there, they can bring it back. That's fine, that can be fair, and I don't think there's any damages there. Anyone could find that, it's, if it was sold to an insurance company. Yeah, so your genetics get out there, or something like that.
Yeah.
Those are issues.
but they're honest.
yeah, those are issues and yeah, I guess one concern I have is that who's watching? I mean, we as individuals obviously aren't watching, who's watching some of those sales, who's monitoring that so that people even know to start curing or ask for a cure. I mean, that's a concern I have is how do you even know that something's happened with your data?
Their notification.
No, there's no. Okay,
And I don't know if it's in your contract. It's-
So- committee, we have three choices in front of us. We have concurrence, we have concurring with a further proposal amendment, which I think would be just to not agree. Or we could ask to go to a conference committee. Or sorry, fourth choice, I mean, we could just not concur and see what you guys do. How about that? Is that an option? That's one.
Well, if you don't concur,
It's nothing happens.
yeah, you have to request comments.
And you want something like request options, and if that's possible, we have to be able, I think, to provide the House with evidence and examples of when that would be appropriate. And where it could in fact be cured. That's really the case.
And I wonder if it's their way of fighting that out there. There are pieces of that that get out that's been not there.
So we could explore that further. So
Even the uncurable things could still go through the same cure period and end up in the same results. I just think it's a fair process for both sides. So that's where I am. But I
Okay.
think we should have a cure period in these circumstances.
Not concur.
okay. Is that okay with everybody? Okay,
Yeah.
I will stand up
From
and
our
say,
perspective, it leaves with this, I think, to go to the committee of conference with some evidence. That would
well,
be-
I think we have to,
It has to be.
okay, I will ask for a committee of conference. And thank you for sharing this concern, Mike, we appreciate, and if people would like to serve on the committee of conference, please let me know. Because yeah, we're gonna go off live and go, we're being called to the